Welcome back, everyone. We're coming to the two last session of today. So upcoming is the last panel discussion on working with the law experience of Southeast Asian lawyer in promoting and protecting human rights and environment. This panel is co-organized by Community Resource Center and Network of Environmental and Human Rights Lawyers in Southeast Asia. Fabio Nesta will be the moderator of this panel. May I invite Fabio on screen?
Thank you, Jerry.
Yeah, good afternoon, Fabio. So Fabio started his law degree as a lawyer assistant with LBH Jakarta in 2005 and officially admitted as a lawyer with Indonesia Association in 2007. He has been involved in various legal empowerment, advocacy, research, and strategic litigations. He is among others who are advocacy or research on the freedom of religions or belief, anti-torture, refugee protection, and fair trade. So Fabio, over the floor to you.
Thank you, Jerry. Good afternoon, everyone. My name is Fabio Nesta, and I'm working with the Indonesia Legal Aid Foundation as part of the Southeast Asia Public Interest Lawyers Network. I will be moderating today's session on working with the laws, experience of the lawyers in Southeast Asia in working to promote and protect human rights and environment. As you may already aware, lawyers have been working hand in hand with other civil society actors in protecting human rights and environment by using the law as the basis of advocacy. Various legal approach and strategies, including community legal empowerment, legal documentation and monitoring, legal advocacy, strategic litigation, or any other legal approach have been taken into account in pursuing legal remedies and accountability in many cases of human rights and or environmental abuses. In this session, we will further discuss on the role of lawyer in promoting and protecting human rights and environment by presenting 5 distinguished panelists who will share their experience in working on these issues. So we have with us, the first is Grizelda Mayo from the Philippines, who is working with Environmental Legal Assistance Centers Incorporation, or ELAC. And the second, we have Asep Komarudin from Indonesia, who work with Greenpeace Southeast Asia, Indonesia, and member of SEAPIL. And the third, we have Jessica Binwani from Malaysia, who works with Sahabat Alam Malaysia, or Friends of the Earth Malaysia. And the fourth, we have Charles Hector, a lawyer from Malaysia. And last but not least, we have Sor.Rattanamanee Polkla from Thailand, who works with the Community Resource Centers. All panelists will be given 8 minutes, 7 to 8 minutes each, to explain what the environmental cases that he or she handling, how he or she use role of lawyers to support community and CSOs on the environmental cases, what the challenge or risk that they works or face in the role of lawyers or on environmental cases in country and region. And the last is what the suggestions or recommendation for role of lawyers to work on environmental cases in their country and this region for Mekong and ASEAN redesign. We will have a Q&A right after the panel presentation. Should you have any questions during the panel presentation, you can use the chat box to write your questions, and I will give you the priority to speak. Without further ado, I invite the first panelist, Grizelda Mayo, to share your presentation. Over to you, Grizelda.
Yes, good afternoon, everyone. Thank you for the invitation to be part of the Mekong-ASEAN conference. I'd like to share my screen about the work that Environmental Legal Assistance Center is doing. Okay, I hope you can see the screen. Is it clear?
Yes.
Okay, so this is, I belong to the Environmental Legal Assistance Center, and our hashtag, if you would call it, is helping communities defend the earth. So Like most of you, we are a non-government organization, and we do work with a group of lawyers, paralegals, researchers, and we have volunteer lawyers and scientists. So the issues that we work with, using the human rights lens in focusing on environmental, public interest environmental lawyering, we work on issues like ancestral domains, biodiversity conservation, issues of environmental justice, land and coastal pollution, environmental governance, and many others. And it has been our experience as lawyers that when we try to respond effectively to these issues, we have to deal with governance. Okay, you talk about unsound policies, poor resource management, weak governance, poverty, lack of awareness, corruption as part of the environmental governance issues. And this is the various legal aspects of our work. So we just do not help in crafting local policy or local legislation. We also work with communities, with government, and even academic institutions in management. Enforcement is a very challenging area of work. We also push for ancestral domains or community-based forest management agreements as part of our effort to address legal tenure or tenurial issues. Okay, I mentioned already governance, and resource use conflict is a common problem. So these are just some of the photos I'm showing you that the main communities we work with are indigenous peoples, farmers, fisherfolk, women, youth, okay? And we do what we call legal clinicking and mentoring sessions so that the paralegals, the community paralegals whom we train, it's not enough to do one training or one seminar. It's important to do a follow-up and a discussion or a dialogue so that we are able to monitor to what extent they have been able to work as a paralegal, to what extent have they been able to use their rights and avail of the remedies under the law. So that's part of the sessions that I've mentioned. We do have strategic legal and advocacy intervention. So public interest environmental litigation is part of the work we do. So protecting a forest resource on ancestral domain against an extractive project as mining. We do advocacy work because there's a lot of monocrop plantations encroaching into forests, ancestral domains, and even productive agricultural lands. We are also into an advocacy work pushing for renewable energy and clean energy. Changing of zones is also a problem that we see because we do have laws which provide that these are protected areas or watersheds, but they are being changed or revised. And then if infrastructure development, because you see roads being built without environmental impact assessment processes, without free and prior informed consent processes, we see also illegal reclamation. So build projects that do not comply with human rights safeguards and environmental safeguards. Okay, these are again additional photos showing you that the farmers visited our small office and we were getting their statements and doing their interviews. Okay, this is a photo of an illegal reclamation and port development project where once upon a time they were full of mangroves, but there were no enforcement efforts. And then just we saw that it was being reclaimed. So it's a big issue for the fishers because the area is a seagrass bed, okay? And they also fish in that area, and that's also a mangrove area. So you see this not only happening in the province where I work, but also in other parts of the country. But as part of our advocacy work, we do engage with government agencies and the private sector. So if the laws that we have provide for multi-sectoral consultation meetings or interagency meetings, we participate there and voice out the concerns of civil society and local communities. We submit position papers on any type of issue, and we articulate the social justice issues, human rights issues, environmental justice issues. And we participate in field investigation activities, including multisectoral enforcement efforts. So press conferences are what we call meta-legal remedies. So we show to the public what the issues are. We let the indigenous peoples, the local communities talk, and civil society leaders. Why? Because we want to bring to the public that these issues need to be addressed, and there are rights being violated, and there are remedies that can be availed of because of these violations. Now, education is an integral part of the work we do because we do need to pursue legal empowerment. ELAC is part of the alternative law groups, and legal empowerment is actually part of the work we do. Okay, so we do have radio programs, we do have trainings, and legal resource build up through law student internships, science internships, or developing volunteers are also important areas of work because you need to develop future lawyers, future paralegals. Okay, so these are some of our meetings I'm showing you. And then the challenges and the risks. When we do our work, there are a lot of institutional issues in government. There's weak enforcement, there's low budget for enforcement, research and monitoring, okay? And then there's also legal tenure issues. There's a lack of lawyers in remote areas. Plus, we also deal with harassment suits and security risk issues. So among our good practices before I end, and this is also a recommendation of sorts, for public interest lawyering, it's important to work with community organizations and civil society groups to assess the readiness of a community for legal actions because they may not be ready. They might want to choose advocacy work or education. And then if we do have to initiate cases, it's also important to assess the integrity of our witnesses, how prepared they are for the judicial and the rigors of judicial and administrative remedies. It's also important to ensure regular communication and coordination with members of the legal and science pool. And then the strategies have to be revisited because you engage with government on one hand, but on the other hand, you may also initiate actions because they fail to do their job. And because we're also suffering from security risks, okay? We have done security protocols. We have done awareness sessions on security, digital security trainings, and establishing security protocols. These are important. They're what we call red tagging. Certain community leaders are being identified as communists, terrorists, and that's bad. And in the Philippines, we've had our share of killings of lawyers for the last 6 years, and that's very tough. So it's important to capacitate ourselves with the security measures and security protocols. Plus, I think my last point is on regular staff meetings. We should not lose sight of building confidence, bonding among ourselves, especially now under COVID. It's up and down. So sometimes you have a lockdown, you do online meetings, but still it's important that we monitor ourselves. So I think, thank you for listening. I hope I stuck to 8 minutes. Thank you very much, and mabuhay.
Thank you, Grizelda. We have learned from Grizelda the experience in the Philippines run her and her organization Advocacy to promote and protect human rights and environment. Now we can move to Indonesia experience. I invite Asep Komarudin to the floor. Over to you, Asep.
Thank you, Fabio, Nesta. It's great to be here and meet you all by online. So unfortunately, I'm not yet sending my presentations, and I will share a letter about my presentations. For your information for all, my name is Asep Komarudin. Currently, I'm in Greenpeace Southeast Asia Indonesian office. Currently, I'm leading the climate litigation project here in Indonesia, and also member of the SEAPIL. So as you all know that we are, of course, that Greenpeace is the campaign organizations So we are a bit different with the I think almost all of you that most focusing on the advocacy part of doing daily activities. But in Greenpeace we are is the campaign organizations, but in a long way that we also doing some advocacy work that but of course that the advocacy work that we are doing is not do by ourselves, but of course we are collaboration with the lawyers, with the other civil societies relating how to using legal for advocacy. In our in our program that we are using law also as a tool for campaign. So in our internal, we categorize law using law for three categories in our daily activities. So using law as a sword, it's mean that using legal and law for attacking. Yeah, it's for using law as a legal actions to challenging and then related to suing cases and etc. And then also the other part is using law as a shield. As you all know that we are working in the environmental issue. It's one of the most dangerous issue in Southeast Asia. There is a lot of attacking related to environmental activists and etc. So we are using law as a shield for our of course when we are got the attacking from the criminalizations, slap and etc. So that we are functioning law as a shield. And the other one is we are using law or legal as armor. It's mean that before that we are doing some things, campaign, publishing our research and etc. We are preparing and compiling. Yeah, try to be compiling with the all the regulations so that it will make for our publications and campaign activities more at least more safe on the legal attack by the opponent. So related with the current situations, it's using legal asword in Greenpeace office. Of course, also in Indonesia, it's becoming a more what we call it, becoming more often to using. So we had a few cases that we are doing here. From the administrative court, we are challenging revoking the permit of the one of the industry activities, and we challenges about the permit to the administrative court, and then using the court of the informations court commissions also related with the right to the informations. So we also using that mechanism for our activities. And then of course we do challenges also using the citizen lawsuit and then class actions. And currently there is some good news. Few weeks ago we are with the coalitions here in Jakarta. We are winning the case about the Jakarta air pollution cases that is surprisingly almost all what we demand. It's giving by the court, and a court mentioning the presidents and then some governor and some the institutional filer, and they against the laws related with that decision, because they cannot fulfilling the right of people for healthy air in Jakarta. And then, like I told before, that we are doing with our legal action collaboration with the civil society, and then also with the community. What we call with the movement lawyering. We are creating the movement lawyering, so it's mean that we are connecting the lawyers and then the community at the grassroots level. They collaborate each other. So it's mean that they will we creating the same understanding, mutual understanding at the ground level between the communities and then the lawyers in the local. So at daily they will work closely together related with the cases that they been taking, like the community suing the corporate because of the land grabbing and or etc. So it's mean that we are trying to creating the ecosystems between community and then the lawyers. So it's mean that there is a capacity for the community also, and then improvement for the capacity for the lawyer. Yeah, as you know, with the current situation here in Indonesia, the capacity related with the environmental cases, knowledge in the lawyers, it's very limitless only. So few lawyers can have the experience and then capacity to working with the cases, and we also we also giving them that working with the related with the environmental cases is not only environmental cases, but it's also connecting with the human rights, and also it's also with the about the climate change. So that's we are giving the capacity to the lawyers and then to the community, and then for the community, of course, that we giving them the understand about their right about the healthy environment, and then they right about their land and etc. So they can send loan saying that this is what we want to do. We will taking a legal action. So it's mean that the legal action that been doing is not come from us the outset from the community, but the community saying by concern by them, so they want to taking a legal actions for our cases. So it's mean that that part that we are working on. And yeah, of course, with the current situation, the challenging and the risk, of course, there is always risk when we are working in the environmental cases. It's like I told before, it's the more dangerous issue here in Southeast Asia. Yeah, SLAP also, it's becoming another challenge. And what I'm suggesting is both with the networking and collaborating each other, it's and supporting each other. It's more, it will be helping for lawyers in every country or every regions to working on the environmental law and environmental cases. Thank you, Mayo. I think that is my first, and then we can discuss more later. Thank you. Over to you.
Okay, thank you, Asep, for sharing your experience with in Indonesia advocating human rights and environment. So we have learned from Asep experience, who mainly working mostly in campaign. But however, in terms of advocacy, Asep also would work with the NGO network who focus on advocacy, doing strategic litigation, and not to mention providing some so-called SEAL to protect human rights defenders from attack, and many more. But now we can move to listen to the experience from Malaysia. So I invite Jessica Binwani. Over to you, Jessica.
Thank you, Fabio, and good afternoon, everyone. And thank you for inviting me to this meeting, this Mekong Awareness Week, Environmental Awareness Week. So taking off from where my colleagues from Philippines and Indonesia have spoken, you may or may not be familiar with Sahabat Alam Malaysia or Friends of the Earth Malaysia, which is a part of Friends of the Earth International. And just like the work that is being done by our friends in the Philippines and Indonesia and many other ASEAN countries, we also do advocacy, education, outreach, and research on human rights and environmental issues. Basically all sorts of environmental issues. But my focus of my presentation today will be a couple of cases that have been handled recently by us, Sahabat Alam Malaysia's lawyers, relating to very current environmental issues in Malaysia and the strategies that have been used. So first, I'd like to touch upon the case of the Penang South Reclamation. This is a project that one of the state governments in other places, you might call it a provincial government, but in our case, it's a state government, the state of Penang. The government basically plans a massive master plan, transport master plan worth 46 billion ringgit, Malaysian ringgit. And in order to fund this plan, the plan was to reclaim 3 islands at the south portion of Penang Island, and these islands would then be sold, or rather used to gain financing for the transport master plan. So the thing that worried environmentalists in Malaysia about this plan is that the 3 islands would span an area of 4,500 acres and would be diminishing, or not even diminishing, destroying completely an area which is very rich in fishery resources, mudflats, mangroves, and and is also a very rich area, biodiversity area with turtle landing sites. It is also an area which is the source of livelihood for many thousands of fishermen who live in the southern part of Penang and from other nearby areas in the rest of the country, from Perak and other areas near. So basically, we were talking about the loss of an essential fishery resource for the northern region of Malaysia by the construction of reclaiming the land for, or reclaiming the sea for 3 islands. And these 3 islands would have taken 15 years to reclaim. That's not including all the planned development on the islands, which based on the information that was available, would actually not benefit the locals. So the path that was taken, aside from advocacy and research and educating people as well as protesting against that, was to also engage with the local community, which the fishermen, who were actually very concerned about the loss of their livelihood, but their voices were not being heard by the powers that be. So despite their many objections, the government was pushing ahead with the project. So the fishermen reached out to Friends of the Earth, Sahabat Alam Malaysia, and we assisted them to launch an appeal against the environmental impact assessment approval for this project. So the environmental impact assessment report for this project was approved despite the Fisheries Department, the Ministry of Agriculture, stating that the project would result in an irreversible loss of fishing area or fishing resources. And despite that, the EIA was approved with a whole long list of mitigation measures, which in our opinion meant that actually the EIA should not have been approved in the first place. So a challenge was lodged by the fishermen, a group of fishermen, headed by the head of a fishing unit, Now, this challenge was not in court. The reason I've spoken about this story is to highlight the fact that environmental challenges, legal challenges, need not necessarily be in the courts. There are many domestic remedies and mechanisms which can be utilized to challenge decisions made by authorities in relation to projects, in relation to approvals. And it is a useful, very useful mechanism, very useful redressal mechanism that should be considered when you're talking about challenging environmental decisions, decisions which affect the environment adversely. So a challenge was lodged, appeal was lodged against the decision of the the Department of Environment approving the EIA report for this project. And just a few weeks ago, the appeals board decided in favor of the fishermen and held that the EIA approval was invalid. This was even before they heard the merits of the case. This was purely on the basis that the EIA approval was null and void because it was approved based on a plan for the island, plan for Penang Island, which had not been legalized yet. It was so therefore it was an illegal approval, and so the appeal board held a legal approval and set the approval aside. So by reason of this decision of the appeal board, the island project cannot continue yet, or cannot continue as it stands. So either a new EIA has to be submitted, which will then have to go through the entire process of public participation again, and an appeal process again if it is approved, or if anybody wants, they would have to take the matter to court within a period of 3 months. So the use of this procedure, which has been used for the first time in Malaysia because it is a fairly new procedure in the law, showed us and taught us a very valuable lesson in utilizing domestic remedies or remedies within the laws to challenge decisions rather than having to grapple with taking the matter to court instantaneously. So there are other domestic remedies which can be utilized. So that's one thing that I just wanted to talk about, a recent development in Malaysia. The other thing that, because we were asked to address strategies and challenges, so I'll just talk about a challenge that we face. And I think this has been dealt with in one of your earlier sessions about slap suits. So I just want to talk about our experience with slap suits, which we have a couple which we are assisting with now. Now we have assisted with and are assisting with. And since I've been told that I only have 1 minute left, I'll make it fast. Essentially, there's a strategy in slap suits where the company will file simultaneous suits against many individuals and even news organizations. And we have found from one particular case that is very, very important for there to be coordination between the community, the people who are being sued, as well as the news organizations and the blogs or anybody else who is also being sued for carrying such an article. The reason I'm saying so is because there was a recent series of slap suits against villagers who had protested against a gold mine. And similar slap suits were also filed against news organizations. But what has happened is the villagers fought their slap suits on a different basis, and the news portals fought their slap suits on a different basis, resulting in two very different decisions of the highest courts in Malaysia, the federal court, on the same issue. In one suit, the one where we assisted the residents to fight the slap suit, the court held that the articles which were published were not defamatory and also upheld the right of activists to speak up in the public interest, which is a very important thing in supporting activists in speaking out for matters which affect public health and safety. On the other hand, there is another federal court decision, and this was in a decision, the same company suing one news portal. And that decision has resulted in a completely different finding by the federal court that the same articles were actually defamatory, were false news, and were written without checking the facts at all, and it made the judgment in fact has made the villagers look extremely bad in the eyes of the law and the eyes of the public. So it is unfortunate that we have two very different decisions on the same issue. One in support of the right of an activist to speak out, and one stating that the villagers actually were not telling the truth. And this is all because the approach taken was not, perhaps in hindsight, we realized it was not coordinated. And that is what I wanted to highlight, is that when we are looking at threats and challenges to communities and on environmental issues, one of the threats would be slap shoots. It's very, very crucial for the news portal, the blog, the writer, the publisher, and the community to work hand in hand to ensure that both parties, the rights of both parties to speak up are held. I'll stop here and I'll pass this over to Fabio. Thank you, Fabio.
Thank you, Jessica. It's important to learn from Malaysia experience that you have been working with your organization against island reclaiming in the northern part of Malaysia, and highlighting that the slap suit has been used and also as a threat for the community or the organization, that we have to think of how to mitigate that risk. And I invite also Charles Hector. We would hear more on Malaysia experience in the promotion and protection of human rights and environmental. Over to you, Charles.
Thank you. Lucky we had another Malaysian speaker talk about some of the cases. So I will actually go to something different. Now the question is in terms of, can you show my first slide, please? Now with regards to the talking about human rights and environment, in certain cases kind of things, the first slide at the bottom there's a picture of this bird, the helmeted hornbill, which is a critically endangered species. 150 left in Thailand, maybe around the same number in Malaysia. Who protects that? You know? And then in terms of this thing, can we go on to the next slide, please? Now, in terms of lawyers in Malaysia, interestingly, lawyers in Malaysia, our concern, our primary objective is uphold the cause of justice without fear or favor. And now the Malaysian Bar, for example, has got 20,000 over lawyers. They are all members of the bar. And one of the things that we have actually come out is that. And so the thing is, in terms of in Malaysia, the lawyers are united. And we have gone out even to the streets, organizing peaceful assemblies to campaign. We had 3 major ones which saw the attendance of at least about 2,000 lawyers coming out there. You know, the pictures are there in terms of this thing. And so that itself kind of things shows that something that has happened, so that in terms of convincing the bar. So this is a call to the other countries, is that in the sense, can you convince your law associations and your bars to also uphold the cause of justice, uphold and protect human rights and the environment? That's one thing. Now the bar is actually not just speaking out. Next slide, please. Bar is not just speaking out. From time to time, we are a democratic organizations. Our elections are held once every year. Once every year, we change our council. And during this time, we also pass resolutions that are binding on the bar from that time until it gets revoked. So the thing is, one of the things that I wanted to share with you was that in 2014, we have a resolution on environment and climate change. You know, we are calling in terms of the bar, calls on the government, and the bar is working on it for effective enforcement of environmental laws. Urgent legal reform were required, including ensuring transparency and proper public consultation with all stakeholders, and not allowing ouster clauses to prevent judicial review. That means even after the minister has made a decision, we can still take the matter up to the court to challenge a decision of the minister. So now this is just one example of the resolution and how lawyers operating beyond just in cases, but becomes also human rights defenders protecting the environment and promoting the rights, human rights and environmental rights. Now, I'd just like to talk in terms of some of the realities, hurdles, and needed reforms that we are actually looking at. Next slide, please. Now, the biggest problem with regards to especially environmental rights or rights associated with the environment is ignorance of the law and the available rights. This, the people themselves are not aware. Because in terms of any decision making or by the government department or ministry, the people have the right to actually object to the decision, and that objection would have to be taken into account by the authorities. If the authorities decide the objections is not valid and keeps it out, then you have a right to appeal to the minister. And then you have a right, if the minister's decision is still also not satisfactory, then you have a right to take it up to the court. Many people are not aware of this. So sometimes what happens is that, because that in itself is actually, is a problem, so that the people sometimes, when the whole thing is already done, that's very distinct. The second is in terms when the law or the government itself hides or removes some of these people's consultation participatory rights. Like, for example, the environmental impact, EIA, impact assessment. Okay, there are two sets of things that requires environmental impact assessment. But in the list number 1, it says, do not require public display and public comment. That itself is wrong, because in the sense that it actually cuts off the people from participating in the process. Point number 3, theft of people's right of participating in decision making. Malaysia is supposed to be a democracy, but the reality is Malaysians in their local villages or even the local smaller communities, they do not democratically elect their leaders and representatives. In the local government or the local council, again, the Malaysians don't have the right to actually democratically choose and elect their local council or the local government people's representatives. All these are politically appointed by the state authorities. That means, and this is a problem, because when it comes to actually approval of the people, the government or the authorities go back to these political appointees, and they, without consultation of the people, will sign a letter, give a document, says we consent, we agree. And of course, there is speculation that there could be a lot of other things. Maybe one is a worry that they might lose the power, they might not be appointed further, they might be kicked out by the government of the day, and somebody else will be politically appointed. There's also the factor in terms of money. So that is number 3. Number 4, can we go to the next slide? Now, bad laws that really do not protect the environment. Let's take endangered species. Not only wildlife, but also plant life and all these kind of things. Now, if you look and study in terms of these laws basically criminalize hunting and trafficking of animal parts and so on and so forth. But it is not protecting the habitat. For example, when you look at the helmeted hornbill kind of things, if you don't protect the habitat where it lives and survives, are you being concerned about protecting this endangered species? So in the sense that this is the trend in Malaysia, possibly also in terms of other jurisdictions, that we need to change this and move towards protection of the habitat. Next point, the role of government is confused. Now, the government is supposed to administer, it's supposed to ensure justice, it's supposed to be the monitoring body. But what happens when it is the government itself that becomes the business interest? And either it's a statutory body, or it's a government-owned company, or there is a government-linked or controlled company. So when the project, for example, forestation, deforestation, or logging project is given to the government, now who is going to play the independent role of actually monitoring and ensuring that human rights and this thing, because the government is in conflict. You know, do they protect their companies or their potential source from this so-called economic activity, or do they protect the best interests of the people? So that is a problem. Because in a recent case that I was involved in for a short while, in terms, the project was given to the state statutory body. And on top of the state statutory body, who sits there? It's the chief minister. So in terms of protest, appeal, whatever itself is being, all this are being considered and decided upon by the state government or the state government departments as to whether logging be allowed or not allowed. So how fair, how independent would such government authorities be in this such situation when this happens? So will they be with the people, with the environment, or would they be with the profits that they're going to get from exploiting the forest? That is the thing. The next point is terms of people's fear, culture, consciousness. Now, in terms of generally, when it comes to environmental rights, even when your rights are violated, many people are afraid to actually go forward and challenge the government or the authorities. They are worried about repercussions. They are worried about whether their children will get government scholarships. They are worried about their housing rights and all this kind of things. So that is a real concern. And then there is also the culture that exists. In terms, Malaysia might be a democracy, but in terms of reality, people still behave as though it's a feudal state. Replacing the king and the royalty are the new political leaders of the community or the government. So the thing is, the culture is actually, in terms of any issues whatsoever, they will take the easy way out in terms of trying to appeal to the government or to their member of parliament from the ruling government party to change. So by doing this kind of things, they don't actually fight or struggle for their rights effectively. And many a time their protests and their comments actually can and will be suppressed. So that is this one. Then of course there is also the other risk, and there is also the question of challenging or enforcing or defending or your rights and so on and so forth. If you take the process to court, for example, the problem of the biggest worry is in terms of cost. Who is going to bear the cost? Because when 8 people of the community, do the rest of the community actually support these 8 people? Do they all come and pool in their resources so that, okay, this is what you're going to fight? And in the courts, what happened is that for every little application that you make, and the court actually dismisses that application, they penalize the people by awards of cost. For a country that has got a minimum wage of 1,200 Malaysia ringgit, in the cases that I've recently been monitoring, is that they issue cost of 5,000 ringgit, which is a lot of money for the ordinary people. And there's not much of a resource, because unlike Thailand, Malaysia does not have a justice fund that actually, provides, allows the people, especially the poorer communities, to be able to access money given by the state so that they can ensure some sort of fair trial, a fairer trial when you are competing against corporations and businesses who are much well off in terms of resources. Now, in the recent forestry case kind of thing, the other problem that I discovered was lawyers, the issue of lawyers and conflict of interest. Many lawyers and their law firms actually don't have much ability to get their own individual clients. So they end up becoming members of panels, legal panels of banks and legal panels of state institutions. So if you are a legal panel of state institution, or whether it's a local government legal panel or whatsoever, then you become conflicted. Like in this logging case in Pahang, the license holder is the Pahang State Statutory Body Managing Director. So how to take up that case? Because you are also this thing, and then you have got a secondary consideration that comes into picture. If I take up this case, I might lose my fellowship and my regular source of income from other issues. So that is basically some of the points that I wanted to highlight. Do I have any more time?
I believe that you have plenty of information that you would like to share, but can we move to the other panelists? And if we still have time, in the discussion, you can continue sharing.
Yeah.
Okay, thank you, Hector, for sharing your insight.
Yeah.
This is also important that Hector has also remind us about the reality that that many people do not realize their right to object. The government often hide or remove the rights of the people. There are bad laws, government business interests, fear from risk, and not to mention lawyers' conflict of interest. And from Malaysia now, we can move to our last but not least panelist from Thailand. Sor, over to you.
Thank you, Mayo. I have few slides to share just to make the easy for me to present. Actually, what I want to talk about the litigation and advocacy as a lawyer in Thailand. That I am working for the Community Resource Center Foundation. That I am a co-founder for the organization. We start with the litigation. We would like to provide litigation for the grassroots people and also civil society in Thailand. That is our starting. But after that, we found that when we talk about the role of like support for protection, or we realize that it's not only litigation that we can do as a lawyer. We also can join with other and working with other organizations to work on the so-called intervention and also building capacity and supporting the struggle of the people. And also, we can helping for the promoting the human rights and community rights and also environmental protection. What we do here, I actually, whenever we go to the court, we used to provide the litigation, and we are not only sitting in the court and working in the court inside the courtroom, but we used to call our community that we are working with to come to the court to learn from reality, to make them understand about the law, about the procedure. Then after we finished in the courtroom, we used to come to like explain to the community what is happening in that day and also what is the next step, something like that. And also, as I say, we are not only working as a lawyer, but we have a lot of cases that we analyze the issue of the case. Like we work on the mining issue, we work on the development project, and we realize that all the thing is related with the business and human rights, related with the mechanism that we can bring it up to other level. Then I used to attend for like bringing the cases, analyze it, and also showing in the panel anywhere that we can do. We join with the some local level, national level, and also regional level as Asia. And also we bringing it up the cases to the international level. Also we bring the case to the working group on business and human rights in the UN mechanism to ensure that all the information that we have, all the principle that we have to analyze in the cases, we can bring it up to change the policy. Because when we work in the cases in court, you will get the judgment, you will get the good judgment, and also you will get the bad judgment. And then we can bring all that thing to bring it up to change the policy. to request to ask for the changing any kind of the information, any kind of litigation process or the law and regulation. And also we also joining with other organizations to do the seminar, public seminar for the issue that we are working. Actually, nowadays we focusing with the business and human rights situation in Thailand. Then we join with other CSO when we realize that government want to develop the national action plan on business and human rights. Then we bring all the cases that we are doing for the environmental issue, for the transboundary issue, to request that the national action plan should accept our recommendation on the law and regulation to adopt as a national action plan. And then we joining to make the like a public seminar and also follow up the things. And every time when we used to when we go to court, we not just like going quietly. We would like to bring all the like the community members and other activists to come to join us as well. In this photo, it happened for the Sayaburi Dam when we filed the case in administrative in Thailand, administrative court in Thailand. And at that time, luckily that administrative court open for the media to come. You can see in the room that there are a lot of media come to shoot for the for recording our press release. But right now, a lot of court in Thailand, even justice court or administrative court, they not allow any media come inside the building to make the like the press release, whatever. Then we cannot do like this. As we are working, I have the case to show that Thailand never have the so-called what is called mental compensation for the mental damage. And we use the case, this is the group of the community, we use the Kuha case for the, is just only limestone mining to ask that the company need to pay for the mental compensation for the victim. And we use this case as a small case to be a big thing that the finally the Supreme Court accept that when there is violation, the mental damage should be granted for the compensation as well. Then we bring this case from the court to the UN meeting on the ESCR for the reporting of the Thailand to make the government accept this idea, and then it's become the changing for the remedy for the people. That is why we used to say that we making a small thing to be a big thing. And yes, we are not only law user, we're not lawyer who use the law, but we use the we also doing as a lawmaker. We can change the law, we can do the law. And also I actually not working only for the case in the domestic case, I also doing for the transboundary case that the Sayaburi Dam is inside Laos. Actually at the Mekong River, but this part is just only inside Laos. We try to see how we can use Thai law to support the victim from either from Laos side or for Thai side who get affected with the dam. Then we also file the case for the asking for stopping the project and also making accountability for the project as well. Then when I would say for the cases when we are working, we can use our law for protecting the people. And also we have to think how we can do the extraterritorial obligation whenever Thai Thai investor going to other place, and I used to get complaint from our Myanmar friend that, you know, now you stop the mining in your country, but they come to our country. Then we also have to work for the transboundary impact and also seeking the law, how we can support them, as we are doing for the, we call Odamenjoy sugarcane plantation, that the victim in Cambodia, they got the land grabbing from the Thai company. We also bringing them to the Thai court and filing the case, asking remedy from the Thai company by our system, that is the class action system, that is now the justice court accept the class action system. Now our case is also ongoing, and I would like to see our region need to work in the collaboration as like a lawyer network, that we can work together in the cross border, that Jessica also talking about the issue that is investment from the Singapore, but it's impact to Malaysia. That is also another thing. Also, I hear about the cases that Singapore also have a law for the hash, that we don't know, maybe we can also working together for supporting the victim from the environmental impact. Thank you.
Thank you, Sor, for sharing your experience, that you often involve the community to the court to learn the process and discussing it with the community after they return. And you also not only bringing your case into the domestic level, but you also brought it to the available regional and international human rights mechanism. And not only using a legal strategy, and this is really interesting, that you're not only bringing a big time litigation, but you also use a small cases as an example, as a way that to promote. It could be a small thing to be a big thing, to promote something small to become a big thing. And we have learned from the 5 panelists in this. Now we need to hear from the participants from the floor for any comments or clarifications around this topic. So is there any comments or questions from the participants? Please raise your hands. And I also thought by the organizers that that there will be a comments from participants from Vietnam. Is that right, Sor?
Yeah, but I did not see from the participant from Vietnam yet.
Oh, I see.
Yeah, actually, because of we changed a link for the account, is because of the it's because of in the morning there is some technical problem, and then we change the link, and maybe the other cannot follow for our session.
Okay. If there is there any questions or comments from the participants, you may raise your hands. Or perhaps while we still waiting for any comments or question from participants, I realized that Hector previously would like to continue your sharings. If you do have something to share more, Hector, please.
Yeah, just a few things up, because I personally have actually been a victim of a defamation suit for highlighting human rights. I've also been actually recently in a logging case. There was an application for contempt proceedings against me. Now, in that itself was actually, I'm acting for my clients. And then when you actually commence the contempt proceedings against me, that means it actually gags me. I can't actually continue acting for my clients in the contempt proceedings itself. So that's a new strategy that is using. That means even personal attacks against lawyers themselves, who are acting for clients in environmental case, is something that actually has to be considered. Now, in terms of any of the environmental case, the other big problem is that lawyers can only act so long as their client actually agrees. And the problem is that when the clients actually don't want to attack the state government, the clients don't want to do this, don't want to that, then lawyers themselves become actually changed, and you can't actually continue an effective strategy in terms of acting for issues. And just talking about media itself and SLAP, I think so. The whole problem nowadays in the Malaysian media circle is that little do the people's voices get heard, because the media just generally just does not. So even in the case itself, what happened was that when the media picked out quotations from an affidavit already filed, which is a public document, the client, one of the members of the human rights defender from the community, received 2 letters of demand for the defamation from the plaintiff and the plaintiff's lawyers. 2 different defamations of this thing. Now, in terms of fighting against big corporations and businesses and state, there's a lot of other problems. In the case that I was involved, when there was a report filed that they had caused nuisance, but when they went to the police station voluntarily, without being escorted by the police kind of things to participate in this thing, they ended up getting arrested. Their DNA sample was taken. They were fingerprinted, photographed, and not allowed to be released unless they provided surety. So the kind of this thing, it's not just in terms of legal in the courts itself, but also in terms of the administrative structures itself can be used by corporations, and especially state or state-linked corporations. So that's this thing. So this is the dilemma of this thing. But also just to add on, in terms of I talked about the Malaysian bar. The Malaysian bar, being what it is today, has also set up various different committees. One is on environmental law committee. There's also a legal reform committee. And these committees are also actively trying to campaign. Because in the struggle for human rights and environmental rights, we need as many different parties and groups to actually push forward this. So this is actually, again, another role of the lawyers that many might not be realized, is to push your own law organizations to actually get on board to fight for human rights and environmental rights. Thank you.
Thank you. Thank you, Hector. This is important that Hector has previous experience being attacked by some so-called as judicial harassment. And I also noticed that Sor, you also have similar experience being interrogated by the military with regard to your case. Can you share some of as well, and how you mitigate that?
Sorry, can you repeat again? I was interrupted.
I noticed that you also have experience being interrogated by the military, by the authority, in handling your case. Can you share a bit of your experience and how do you mitigate that?
Yeah, actually, it was during the coup d'etat government that they asked all the activity cannot gathering, or if something happened in the hotel or the resort, the hotel and resort have to write a report to the military that okay, there is some activity happen there. And I was organizing the community meeting for Sayaburi Dam issue, and this is the government, is like a government project, right? Then the hotel just report to them, to the military, that there is some activity, and then military just came to our hotel and asking who is the organizer, and then I just talk with them. They asked me to go to the military camp to like get the what is that, permission to organize the meeting. And then I explained that this is the it's just only client and lawyer discussing or meeting. We don't do any other activity like that. But they said that no, we cannot allow you to have the activity until you get the permission. But because of I am with other activists also, and then we just discussing, and then we asked the military that if you want us to make the letter, just bring that letter to us. We will not leave our client because of we don't know what will happen if we are lawyer left them, right? Then the military calling to his boss, and then after that they went to the military camp and then get the letter to ask we to sign. And I just explained that this is about the role of lawyer. It's not any kind of other things. And then they just the paper already stamped to allow us to have a meeting. But when we found for the is kind of threatened like this, we have also thinking how we can deal with that, because in the some, I would say that some lawyer who don't understand about the role of their work, sometimes they also feel fear, and then they will leave the client. But we cannot do that. If we leave the client, then how the client will be protected, right? Then we have to be with them always. And we used to get, sometimes we went to, there is our colleague went to the mining area to have a meeting with the community in the village. And then because of the villager, they are not aware of the security. They just post on the Facebook that, oh, our lawyer come. It seems like they try to say, they try to show that we have some people come to protect us or come to help us. But in another way, is also risky for them to show that now what we are doing. And then finally, somebody came with the van, with the government van, and come to ask what we are doing. And then our colleague also just try to explain, and then we finally stopped the meeting, and then we went back because we don't know what the exactly list. Then we also have to be aware. Then when we I think when we are working in the kind of putting ourselves in the risky cases, we also have to analyze about the security concern. And this is another way that we can work in the long run. Anyhow, if we need to face or struggle with the risk because of we have to protect the people, then we also can do in front. We can be front line of them, because we cannot hide standing behind them to let them go. We can. I used to talk with the community that we can work together. We are not just only come to support you, but we are work together. Then this is more making easy for working together and feeling solidarity for working with the community. Thank you.
Okay, thank you, Sor. And if we talk about slabs, because some panelists also mentioning about slabs, including Jessica, you also mentioned about slabs. Is that also include the criminalization, or do you mean it's only apply for a tort claim or civil lawsuit?
So far, that we have seen, there are tort claims for libel and slander against activists and against lawyers and other people who have spoken up in the public interest. But yes, there was also recently a claim of criminal defamation, where they have, because we have two areas of law against defamation. You have the civil aspect and you also have the criminal aspect. So the criminal aspect is where the police comes in and people are charged for criminal defamation. And that is actually ongoing right now in relation to one particular case which affects a very large sphere of Malaysian life because it involves the purported, well, the stealing of public money. Let's put it that way. So this was exposed by a particular blog, and that particular publisher or the writer is now the subject matter of both civil and criminal defamation proceedings against her. I just wanted to add on to the issue that Sor and Charles spoke about, threats to lawyers and clients. Just to say that sometimes the threats that are made are not purely to lawyers, but rather to the clients, and it is difficult to overcome the fear that people feel when they are being told that they cannot speak to their lawyers. As much as we may try to help the community, really it is about the community being strong enough to withstand the kind of threats. So for instance, in a case we did some years ago, the community, it was a very small community. You see, it was, they were on their own, kampong. And we were, of course, in the city, and they were in the rural area. Well, the company involved in the activity there had also gotten the assistance of the authorities, the police. So the company had their own people on the ground living within the villages to keep an eye on them and to report back to their supervisors to that if the villagers were meeting with politicians or with activists or with their lawyers for that matter. So while the matter was pending in court, the villagers were living in fear because they were afraid of speaking out, even among themselves, even strategizing, even having meetings, discussing among themselves, because they were all these spies within their community. And in fact, a client of ours was even beaten up for having pursued the case. And he feared for his life and for his family life. So when my partner went down to the kampong to meet him, to the village to meet the client refused to see her. She had to go to a different house and the client was in a different house. And he just refused to just cross the village to come and see her, fearing for his life and that of his family, which is a very unfortunate situation. There may be a fight in court, there may be a battle on the issues, but it's unfortunate that these kind of steps are being taken to. And so when we lost the case at the Court of Appeal, although we felt there was a good case we taken up to the federal court, our clients refused to, because they said, no, there's no way that you're not going to be able to protect us. You can take us to court. You can take our matter to court. You can fight in court for us. We're here on the ground. I fear for my life every day. So enough. I rather have my life and let them go do what they want and destroy the hill and destroy the plantations. I really don't care anymore because my life is more important than anything else. So that is a very real and unfortunate situation that happens.
Okay. Thank you, Jessica, for sharing. I see hands. Gertie, you would like to add something?
Yes, I just thank you. Actually, we're fortunate in the Philippines in a sense that we have the rules of procedure for environmental cases where there is a provision on SLAP, strategic litigation or lawsuit against public participation. However, it is not a guarantee that we will not have killings, because in the Philippines, for the last 6 years, many lawyers have been killed, human rights lawyers and environmental lawyers, plus defenders. So modesty aside, the batting average of experience in lawsuits involving communities who have been sued, including me, is that we are able to dismiss it. However, there is a local official now who was sued by a mining company for abuse of authority, and she was suspended for 1 year. So SLAP suits are not only libel or oral defamation, they can come in criminal cases or civil cases or administrative cases. And in a sense, it creates a chilling effect to those who would want to protect the environment, to protect their ancestral domains, and also to combat corruption. So I think I see the trend in Asia at the moment. So while we do have rules, it's important to utilize those rules and give life to those rules. Thank you.
Thank you, Gertie. And I also noticed that Indonesia also currently developed some actions around slabs. But before we go to Asep, I saw Asep raising hands, but can we go to Pam, who also raised your hands, please?
Okay, thank you.
Over to you, Pam.
Yep. I would like to share our experiences from Vietnam. As you might know, in Vietnam, there is only one party ruling for a very, very long time. And their policies are very important in setting up the legal framework in Vietnam. So that means in that case, we need to check not only the legal framework, but also the resolutions or policies from the Communist Party. And that's interesting that we can find some kind of like a conflict inside the law and policy systems and try the best regulations that favoring the local people's right to participate in the social economic development plan, as well as like a land use planning or forest protection plan, etc. So that is the first point. The second point is that under the very tough control, so it is not suitable for us to do something like a campaign or petition with a lot of signatures. So those actions easily be translated as something like making tension and action against the government. So in that case, it is better for us to find the progressive and good officials who are willing to negotiate or to talk, to discuss with the people who are affected by the projects. And one more thing, as our organization's experience is to get evidence-based research and advocacy. That means we need to combine between our community development projects with research and bring the cases from the local communities to the policymakers and join, for example, the forestry law in Vietnam some years ago. We tried to bring the voices from the local people representative and open up some forums to invite policymakers to come to the field to check what is happening at the field and also to listen to the community representatives. And that's a good way to make them, to help them to see the reality, and they are willing to change the legislation in the forestry law. And I think that's whenever it is you have the better legislation that is favoring the local people's rights. So it needs to be further training and working with local people so that they can get sufficient information and understand more about the law. And whenever they understand, they are willing to stand up and to claim their rights. And I think that's somehow like the long-term working with the community. Yeah, thank you.
Thank you, Pam, for sharing Vietnam experience. But before we continue the discussion, I would like to understand further from Pam around the situation in Vietnam, especially working under the one party regime. Is it quite challenging, Pam, for you to work in that political situations? And do you face any risks or threat before, and how do you mitigate?
Yes, sure, a lot. Not only me, but also the community members and our colleagues. So in that case, I think that we need to check the reality, what is happening, and the relationship between the community, affected community, and the related stakeholders. And we believe that in every situation, we can find some good or better or progressive officials, and we try to dialogue with them, so that the better way to avoid conflict as well as tension between the community, the NGO staffs, and the government sector.
Okay, thank you. Asep, do you have any?
Yeah. Hello.
Please,
Thank you, Mayo. First, I want to, based on our discussion, of course, here in Indonesia also have the similar situations related with the related with the slab also, and challenges for the lawyer or environmental human rights defender working on day to protecting the community and the environmental. So I think the similar situation is it's almost same in Southeast Asia's country, with also with the current situation in Indonesia is more absurd related with our new current regulations. Of course, about the maybe all of you know about the omnibus law. It's downgrading all the safeguard of the human rights safeguard and environmental safeguard in our natural management, just because to inviting a lot of investment come to Indonesia. So all of the safeguard is been downgrading, including for environmental impact assessment that abolish the public participations in the process. So currently there is no public participation in AIEA process now with the current regulation. So and also related with the criminalization, there is one case now. It's not only criminalization but also civil suit. It's for our friend Haris Azhar and Fatia Maulida, who speaks about actually it's about the publications report that written by some few environmental organizations like Greenpeace, Friend of Earth Indonesia, and etc. We are publishing our research related with the deployment of the military and connected with the natural resources in Papua. So based on that report, Haris Azhar and Fatia interviewing in the YouTube channel, and then it's reported by the coordinator Ministry of the Maritime, saying because of the defamation also, and then civil suit to both of them. So I think with the current situation, it's what I want to flagging off is about the how the collaboration between among the lawyers and then human rights and of special environmental human rights defender in Southeast Asia, to how to get supporting each other for, of course, for protecting each other, and another one is how to working together. I think there's a lot of opportunity working with working with the some transboundary cases, and then how to push the standard of the safeguard protections in regional mechanism or etc. So I think that is the part that we can do more collaborate in the future, Mayong. That's from me. Thank you.
Can I add something? Fabio?
Thank you, Asep, and please, Hector, I still unmute.
Yeah, because in terms of the different countries, what we have noticed is that there are certain regulations and laws in certain countries that are positive. And so in terms of sharing those laws kind of things would be quite good, because in Thailand, for example, you've got the Justice Fund law, that will help in terms of human rights defenders in other countries also facing, because there is money that can be, the state supports the money for fair trial. And then from the other aspect is a kind of things is in terms of the violation of the environment or disrespect to the environment. We have to understand that in terms of within certain state governments or local governments, they sometimes don't have a choice to raise money. And so they have to actually go into forestation, logging and whatever other things, So we have got an example in the global with regards to the carbon footprint, and how other states kind of thing. So even within ASEAN itself, to protect and preserve the environment, and wildlife kind of things, that could be that kind of a culture that is developed. That means in terms of ASEAN actually provides you to save the environment, some sort of a fund. Because even the Malaysian context is, the state controls the land and the forest. But some states are poorer, but the federal government kind of thing. So within federations, a similar kind of sharing, because the environment is a concern for all. It affects everybody, So the thing is, some sort of fund at the ASEAN level that could be set up, and even in terms of states that are operating as a basis of federations or separate from the listing, that the federal should actually implement such kind of laws. Now, in terms of also struggling for human rights and environmental rights, the trend seems to be we get attacked first. We get attacked first, So in terms of actually, even empowering the people to actually take the attack first, take it to court first, and actually, and get certain clarification about rights and protections. That should also be a different culture rather than waiting to be attacked first and then going to the courts, rather than that thing in terms of also the other way. Because in terms of, in my strategy, which I employ in most cases kind of things, if they attack, I counterattack with a counter suit against the parties kind of things. Because, just the best defense is also attack. So this is just a few points that I wanted to actually highlight.
Okay, thank you, Hector. I would like to listen more discussions from you all, but the thing is that the time is up, right, sir? Right, Jerry?
Yes, because of there is
Yes.
another activity follow. We use
Okay.
the same Zoom.
Okay.
Sorry.
Okay, so we have learned from the panels that the role of lawyers in advocating human rights and environment is so crucial. By collaborating with the community and NGO network, lawyers could use to pursue remedies or as an armor to protect the community and human rights. Some legal approaches are beyond court case. Lawyers play a significant role in conducting legal empowerment, legal awareness, and advocacy, including providing protection to the community they represent. Some threats are posed against the community that the role of lawyers becoming more crucial, especially the use of strategic lawsuit against public participation in form of criminal or civil or administrative lawsuit. It is important to mitigate that threat by preparing the community with sufficient legal knowledge to enable them to facing the risk. Some recommendation also highlighted during the discussion that it is important to collaborate for a transboundary environmental issue by looking at any available redress mechanism, not only at the national, but it can also be at the international level. And also to prepare the community, the NGO network, as well as the mitigate any potential threat and risk, including the SLAPs. And it is important to use any positive and existing laws and regulation as much as we can to mitigate that risk. So thank you for all panelists experience sharings. I really hope that that the participants and all of us find today's session is useful. Thank you again and good afternoon, everyone.
Thank you.
Thank you very much.
Thank you,
Thank you
everyone.
very
Thank
much.
you.
Bye. Keep safe and see
Have a
you.
good weekend.
Thank you, Fabio, for moderating the last panel discussion of today. And thank to all panelists as well. So audience, we will show you a film shortly. So stay with us and don't change to any channel.